We're already halfway through February, which is pretty amazing, and getting into the springtime and having our first town hall of this year. As Ann said, this town hall is being brought to you by the Golden State Manufactured Homeowners Education Fund. We call that the Ed Fund. This is a companion organization to GSMOL, which has been around for, oh gosh, over 55, I guess going on 60 years now. This nonprofit was formed within the last decade to provide a way for funds to be obtained to help with the work that GSMOL does. If you like what you're seeing today or participating, you can find our website and you can always donate to it. All donations are tax deductible. The Ed Fund is a 501c3 tax exempt organization. So we hope that you enjoy our presentation. Today, what I'll do, as we typically do, is I'll just start out presenting some topics. Then I'm going to move into answering some pre-submitted questions that we received. I think there's 9 of those. And then after I answer those, we'll move on to any questions that anybody online has. So, yep, if you could all just stay on mute until then, that would be great. So we are now in the beginning stages of the 2024 legislative season. That means that any bills that are going to be introduced this year have now been formulated, at least in their initial draft format, and in most cases now numbered. And you'll be hearing a lot more about these as they proceed, as usual, but I thought I would just give a preview today. Our lobbyist Esperanza and I have already been working for the last several weeks on some of the language of these bills, and now that they're numbered and they're sort of, out in the public, we can share about them. So GSMOL has 3 sponsored bills this year, and there are a number of other bills that we've been already consulted about, that we've reviewed, worked on some of the language, that are not GSMOL sponsored bills, but they're bills that have a positive, very positive impact upon mobile home owners and your way of life. So I'm going to quickly just review these. The 3 GSMOL bills, we start with one that addresses the emergency preparedness plans in mobile home parks. And this is Assembly Bill 2022 by Assembly Member Addis, ADDIS. Now, this bill seeks to amend existing provisions of the California Health and Safety Code that pertain to emergency preparedness plans, the plans that a park owner is obligated to draft and file with Department of Housing, HCD in Sacramento, regarding what happens if there's an emergency, if there's an earthquake, if there's a
listening
fire,
to it with earphones.
If there's an earthquake, if there's a fire, if there's a flood.
Oh yeah, I get these because
We're getting some background.
Whatever.
I think Henry, I think you're unmuted. I think we're getting some background noise here. Thank you. Anyway, if there's any kind of an emergency that would require evacuation of the park, that the plan that's on file that's submitted to Department of Housing would lay out how all that happens. One of the concerns that GSMOL members have expressed is that if the park doesn't comply with the emergency preparedness plan requirements, what happens? Is there some kind of a penalty? Is there a way that we could, shall we say, influence or encourage park owners to comply with those requirements of law? One of the concerns most specifically has involved fire hydrant testing and certification. It seems that sometimes park owners are not keeping up with the fire hydrant certification, and that's important to determine, available water pressure in the park in the event of a fire and so forth. And so the idea of this bill would be that if those kinds of issues are not addressed, that the park could lose its permit to operate. And this bill will very specifically require that a violation, if they haven't, prepared and filed their plan, if they haven't kept up with their health and safety, that within 60 days of a notice of violation, penalties could be imposed, and that could result in suspension of the permit to operate. If the permit to operate of a park is suspended, the park is not permitted to operate essentially, which means they can't collect rent from the residents. So that's a pretty stiff penalty, if you will, and hopefully a great incentive if we get this bill passed to comply with law. Number two, we have Senate Bill 1408 by Senator Roth. And this is a bill that addresses the parking of certain kinds of vehicles in a resident's carport or on their space. Over the years, there have been some park owners that act over aggressively about what kind of vehicles you can park in your carport. And there are some park rules, there are some, unwritten policies that parks have followed or attempted to follow that say no vehicle with any kind of advertising on it can be parked in the park, because that is by definition a work vehicle. And I think that just goes beyond the reasonableness of rules. As we know, to be enforceable, rules have to be reasonable. There are many folks that they have to, that's their work vehicle. The fact that it may have advertising on the door or somewhere on the vehicle, they don't have any control over that. This is the vehicle that they drive to and from work. And it's not like they're, stockpiling materials or not, noxious chemicals or things that, smell or could annoy their neighbors in the vehicle. It just so happens it's a work vehicle. And so this bill addresses that issue and would prohibit management from requiring the removal of a vehicle that's used by the homeowner for work or employment and just advertises something on the side of the vehicle. They can't require that that be removed from your driveway or from any kind of designated parking space. The exception would be, which makes total sense, is if you already have one or two vehicles in the carport and you're parking maybe a third work-related vehicle and it's sticking out into the roadway. In other words, it's impeding traffic. It's creating a danger or a health and safety issue. Well, then, of course, just like any other vehicle, you can't park it there. But again, we're trying to eliminate, overreaching, if you will, by management who would say, yeah, if you just got a vehicle that advertises the plumber that you work for, the air conditioning company, it can't be in the park. That's just simply unfair. And it doesn't really go to the purpose of limiting certain vehicles, because again, what we want to limit are vehicles that have massive amounts of tools and everything else in them. They're just unsightly, or that somebody might be using to work out of their home and creating all kinds of noise and dust and so forth. So this bill addresses that situation. The third GSMOL bill is a carryover of the major proposal that we started working on last year. And last year, there was a bill, SB 1035, that addressed the issue of rent caps in mobile home parks. That bill, unfortunately, never got into committee because of the legislature's reluctance to move it forward in light of some litigation that's been filed by park owners against some of the other recent legislative enactments that we've been able to pass. And in particular, there was a bill a couple of years ago by Assemblywoman Quirk Silva that amended the mobile home residency law and provides that if a mobile home park is located in more than one jurisdiction, it's half in one city and half in another city, for example, that there will be rent restrictions or a state-imposed rent cap on that park. Well, the park owners, because there's one park in particular that is in both jurisdictions, that park owner filed a lawsuit claiming that this is an unconstitutional piece of legislation and it's unenforceable. And in light of the existence of that litigation, the legislature felt we really don't feel comfortable moving ahead with SB 1035. We have since then been expending, we at GSMOL have been expending significant effort to redraft that bill from last year. And it's actually an AB, not an SB bill. And it's now going to be numbered as AB 2778. The bill now, rather than putting the burden upon local cities or counties to enact rent stabilization rules and regulations and methodologies and create rent commissions or employ hearing officers, the bill now states that provisions of what's called the American Arbitration Association rules and regulations would be used to conduct any rent hearings. In order to be constitutional, a bill like this, as any of the local cities and counties have done when they pass rent stabilization throughout California, a bill like this, which is designed to cover all the areas that don't have an ordinance, has to provide a due process, fair return hearing procedure. And that has to be constitutionally embedded or provided in the ordinance language, so that if the park owner says, I'm not getting enough rent from these annual rent increases, 100% of CPI or 5% a year or 3% a year, whatever it is, I'm not keeping up. My expenses are higher than my income. I'm losing money. I can't operate the park anymore. Well, they're entitled to file a petition and have a hearing about that. They open up their books. They have lawyers and experts, and the residents have lawyers and experts. And there's an administrative determination as to whether they're entitled to what I would call a special rent increase or a fair return increase. I've actually been involved in one of the most voluminous such proceedings that I've ever done. And out of the city of Petaluma, we just filed our closing brief yesterday. And there's been 4 days of hearings. There's been 10 experts. It's just turned into this crazy monster of a case. And the park owner there wants to double the rents. They're basically saying we're entitled to double the rents for these folks. So that hearing process has to be provided for. And in the new version of the bill that we've been working on, again, that hearing process will now is now described as happening through existing regulations of the American Arbitration Association. We call that AAA. And AAA arbitration is typically always provided for example, in construction contracts. If you hire a general contractor to build something for you, build a house, most likely there are going to be provisions in that contract that say if there's any dispute between you and the contractor, it will be submitted to the American Arbitration Association for some kind of adjudication. In other words, it goes to an arbitrator. It doesn't go to court. Court would only follow later on if the arbitration doesn't result in a decision that both parties will agree to accept. So we've worked on what is now AB 2778 quite a lot over the last few months. And what we've tried to do, and I think the language has been successfully drafted to do that, is we've tried to draft around the concerns of that lawsuit. against the Quirk-Silva bill, and we've tried to draft around any concerns that would dissuade the legislature from moving this bill forward. I have to say that at this point, we don't know whether or when the bill is going to move. There are still concerns about the existing litigation, but we've committed a lot of time and energy to the bill. It's essentially turning into a 2-year process, although this is to emphasize, this is a brand new bill from last year. It's not the same bill at all. Some of it is the same. It's not going to disturb any of the existing ordinances. It's not seeking to make any policy statement about what local cities or counties should do in terms of the amounts that they allow. And it just won't apply to those jurisdictions that already have an ordinance. It's only going to apply where there is no ordinance, areas of the state that have not been able to pass a local ordinance at the city or county level due to the politics, due to their inability, to organize for ballot measures, whatever that is. So the bill is seeking to protect the unprotected, if I can put it that way. So that's going to be a very interesting bill to follow as well, AB 2778. I wanted to mention a bill that we're actually not sponsoring. There's a number of bills that have been that have come to our attention that we being GSMOL, did not actually seek to create or directly sponsor. One of those deals with solar energy. And this is an issue that, in my experience, is coming onto my plate more and more as time goes by, because alternative energy sources, obviously, especially in a state like ours, are receiving a lot of attention. And the sort of green effect, or the green plans or policies that California has been implementing or putting on the drawing boards with future dates, when certain types of energy might become either available or even mandatory. Well, solar energy is a key part of that. And we have park owners who basically tell residents, you cannot install solar on your home. You just can't do it. There is a bill out there that is seeking to address that, and it's Senate Bill 1190. Senate Bill 1190 by Senator Laird deals with solar and mobile homes. It's in a placeholder form right now, which means that it probably it would attach itself maybe even to another piece of legislation in the near future to move forward. But what that bill basically says is that similar to what residents in stick-built housing have the ability to do, that the park owner cannot just flatly prohibit you from installing solar energy. And there's going to be a lot of things to work through in that bill in terms of the park's infrastructure, what it's able to support and not support. But the idea is that you can't prohibit completely and do a complete ban on solar installation, nor can any fee be charged in connection with the resident installing the system. The park owner would not be able to require any particular brand or kind of system, and the homeowner would be permitted to receive any rebates or credits or commissions that come from the solar installation. So that's going to be another interesting bill to follow, SB 1190. There's another bill I'll mention quickly, Assembly Bill 2373 by Assemblymember Rendon. This is an interesting bill because it's essentially, and I think this comes from Department of Housing HCD, as I recall, from some language that they initially proposed last year at the end of the legislative session, but it was too late to get into a bill at that point. What that's saying is that if the park owner does lose its permit to operate, the PTO, as we call it, as I mentioned in connection with the first bill I was discussing this morning. If they fail to pay their fee to renew the permit, if there's any other violation that results in a suspension of the permit to operate, they cannot evict any resident during that time. In other words, because they cannot collect rent, it would make no sense that they would be able to evict any homeowner for not paying the rent, because they're not even permitted to collect rent in the first place, if the permit to operate has been suspended. So that bill kind of just ties down a potential loose end where a park owner says, well, I can't collect any rent, but you didn't pay any rent, so I'm gonna, terminate your tenancy. There's another bill that has to do with the mobile home residency law protection program, and that kind of segues into another legislative topic that I wanted to address this morning before we get to our questions. Last year in the legislative session, we did get a bill passed. It was Assembly Bill 318, and that bill amended the Mobile Home Residency Law Protection Program. We call that the MRLPP. As most of you on this call probably know, a few years ago we passed the MRLPP so that we could begin to find some way to enforce the mobile home residency law, other than residents having to hire attorneys at their own expense, which could cost a lot of money, and in many cases money they don't have, since most of our constituency are seniors, veterans, immigrants, and folks on fixed income. We wanted to put together this program that would enable the mobile home residency law to find some ways of enforcement that residents could afford and be able to access. So the MRLPP provides that additional avenue to resolving disputes by connecting homeowners with legal resources, low income or no cost legal resources that would benefit them if they have MRL violations that are uncorrected. The Department of Housing, HCD, administers the program. They don't directly get involved in enforcing the program. They don't get directly involved in arbitration, mediation, or negotiation. They can't provide legal advice. They serve as what I would call a triage, where the homeowner submits the complaint, they review the complaint, and then they refer the complaint to local legal providers. We call that an LSP, a legal service provider. That's the designation that's made in the bill. So that's been in place for a few years now. And of course, a $10 annual registration fee is collected for every lot to fund the program. There have been issues that have occurred in the program under the previous language that concerned homeowners, and I think concerned HCD as well, because there were some requirements that seemed to make it, and I think probably did make it, more cumbersome than it needed to be. The bill that I mentioned, AB 318, that took effect on January 1st, eliminates several requirements of the MRLPP process. And there's three of them primarily. Number one, under the original bill, HCD, Department of Housing, was to use good faith efforts to select the most severe or deleterious or material alleged violations of the mobile home residency law. In other words, they're doing this triage and they're deciding which are the most serious violations. Those are the ones that we're really going to emphasize. The not so serious ones, maybe we don't move forward. That requirement no longer exists in the MRLPP. That means that HCD will now intake all complaints and refer alleged violations to appropriate legal service providers. The second change is the that in the original legislation, HCD was to select complaints according to geographic representation in the state. In other words, they were supposed to try to equalize how many complaints were being selected and referred out in Southern California with how many were being selected and referred out in Central or Northern California. That requirement also has been eliminated. So, if 90% of the complaints come from Northern California, that's okay. If 90% come from Southern California, that's okay. There's no longer any kind of geographic representation that's required. And the third change is the parties were required in good faith to resolve the matter for 25 days prior to referring or the complaint being referred to the legal service provider. That's also been eliminated so that there's no specific requirement of any kind of number of days. Now, hopefully and ideally, the way this would work is when the park is when it's communicated to the park and the park understands and learns that there has been a complaint filed, that a good park owner would want to deal with that. It would want to negotiate or take whatever action is required to resolve the situation. But there's no longer going to be a specific 25-day period before it could be referred to the legal service provider. So those are important changes in the MRLPP. That leads me as a good segue into the questions that I received in advance of today. And the first question actually comes from Jerry Barnett, and it's a question or two questions that involve the MRLPP, the Mobile Home Residency Law Protection Program. And the first question is, if you're told, if you file a complaint and Department of Housing refers it to the legal service provider, if the legal service provider has said, we're not funded for litigation, and that's apparently in this question what the homeowner was told, we're not funded for litigation. And so the question is, well, what's the expected outcome of a complaint that goes to the legal service provider if they're not funded for litigation? The first thing I would say is, whenever anybody contacts an attorney for assistance, it's not necessarily always the case that the very first step is we're just going to file a lawsuit. There may be exigent circumstances that require that. But when I'm retained, I'm always sending demand letters first or communicating first. If it's a mobile home issue with park owner, I'm not just going out and filing lawsuits. In many cases, you can resolve issues with some legal ammo on your side by demand letters and phone calls and exchange of correspondence, and by shall I say threatening legal action, and basically taking a position with very good law on your side, you can achieve results because people don't want to go to court if they don't have to. Court is like a black hole. It just sucks up time and money. So if a legal service provider says we're not funded for litigation, it doesn't mean they can't help you. It just might mean that if they can't resolve something more informally, they're not funded to actually file lawsuits in the courts. In that case, I would say we need to find a different legal service provider, because there are legal aid offices, senior adult legal assistant offices, La Raza, other nonprofits that are funded for litigation, and they will take action. I know because I've seen those kinds of entities get involved in court cases. So if a legal service provider under the MRLPP cannot, by negotiation and communication, correspondence, emails, resolve it, and they say, sorry, we don't have enough staff to take the matter to court, then I think it's time to go back to HCD and say, we need to be referred now to another provider who is funded for litigation. The second part of the question was that apparently this legal service provider, again, it's kind of like what we would call legal aid, or again, SALA, Senior Adult Legal Assistance Office. When they were told that 8 residents were involved in this complaint, they said, well, we can't handle a group complaint. I would again say in that situation, find a new provider, because that should not really be a problem. If the provider, if the legal office is saying, we're not set up to do what we call class action lawsuits, that's one thing, because a class action can involve a lot of time and money to certify the class that's being represented, and it's a lot more what I would call complex litigation. That's not what we're talking about here, though. I mean, if 3 or 4 or 8 people, are communicating and walking into this legal office and saying, we all got the same problem. The park owner is doing something illegal or in violation of the mobile residency law to all of us. I don't think it should make a difference whether there's 1 or 8 people, other than maybe they all have a bit of a different story and there's more witnesses involved. But again, I would say if any legal office says we can't handle a group of people, I'd go to a different provider, because to answer the last part of this question, are group actions prohibited under the MRLPP? Absolutely not. There's no such limitation or prohibition contained in the MRLPP. So those are the first couple questions I received. Next question: what action can be taken by GSMOL if a park owner does not allow month-to-month ordinance, what I would call ordinance-controlled tenancies? Well, the question is, what action to be taken by GSMOL? The first thing that I want to say about that is GSMOL does not file lawsuits on behalf of its members, typically. There have been a few of those cases that have been filed where, for example, the park owner prohibits GSMOL meetings in the park, just says you can't have them. It's, unlawful commercial solicitation, so you can't have them. Well, that would be a direct violation of the MRL, and that affects the chapter. But GSMOL doesn't file lawsuits on behalf of its members. If you're experiencing an MRL violation, GSMOL can't do that. So if you have a situation that this question is involving, where a resident says, I want a month-to-month tenancy, and the park owner is refusing me, they're saying, no, you can't have a month-to-month tenancy. Well, there's a section of the mobile home residency law that deals with that very specifically, and that's section 798.18. 798.18 of the Civil Code specifically says a homeowner shall be offered a rental agreement for a term of 12 months or a lesser period as the homeowner may request, or a longer period if mutually agreed upon by management and the homeowner. So a homeowner must be offered either a 12-month term or a month-to-month. They have to be offered that if they request it. And if the park says, no, we're not going to give you month-to-month, well, that would be an MRL violation, wouldn't it? This question doesn't have as much legal importance as it used to, because of AB 2782 that we passed a few years ago, that is ending the exemption for long-term leases. Another question I'll be addressing in a moment. So basically, whether you have a month-to-month agreement or whether you sign now, if you sign today a new 5-year agreement, if you live in a rent stabilization jurisdiction, you're going to be covered by the ordinance, because any agreement signed after February 13th of 2020 is no longer exempt from rent stabilization. And I'll talk about that more in a moment. The next question is it legal for a park owner to require fences to be removed? And I think the question comes from somebody who is living in a park that is now either owned or managed by Harmony Communities. And this is something that I've been becoming aware of more and more, where a new management company comes in. They're looking for ways to decontrol spaces and raise rents if the park is in a rent stabilization jurisdiction, or otherwise just looking for ways maybe to even acquire homes. And so they look at the homeowner's file and they say, gee, there's a fence out there and I don't see any permit in the file, or if it's an add-on room or if it's a fence, I don't see any approval. So we're going to give them a notice saying this fence is unapproved and you have to remove it. And the resident says, the fence was here when I bought the house. That was 20 years ago. Nobody's ever complained about the fence. Why are you complaining now? So is it legal to require fence removal? The answer is maybe. If the fence, for example, violates what we call Title 25 of the Code of Regulations, that's the building codes and standards for mobile home parks, then maybe there is cause to remove it. Maybe it's higher than the number of inches permitted by Title 25. Perhaps it's the type of construction is combustible and it's located closer than 3 feet to a lot line and it violates the required setback. So if it's a code violation, then it may have to be removed. But if the park just says, we don't like the look of the fence anymore, we want it removed, the resident can certainly say, well, it's grandfathered in. First of all, there have to be a rule change that says this kind of fence is not allowed. And if they change the rule, the fence is grandfathered in if it's already been there. And I would always argue that if the homeowner didn't install the fence and bought the home with the fence already there, and at the time of purchase, management never said anything about it. They didn't say, by the way, that has to be removed as a condition of sale. The homeowner relies upon the fact when they buy the house that that's my fence and that's it, where it is seems to be fine. Well, the park has waived its rights to then say, months or years or sometimes even decades later that something has to be removed. So the answer is maybe, but in a lot of cases, I would say no, the fence probably doesn't have to be removed because it's not a code violation. A couple more questions. What expenditures for maintenance or improvement cannot be passed through to residents? Is this electricity? This question is referring to the fact that if you live in what's called a master metered park, and that's going to be a park where you have an individual gas and or electric meter at your space that reads the consumption of electricity and gas, and the park reads the meter, the park bills you for your energy. For example, if you live in Northern California, you don't pay a bill to PG&E. You're being billed by the park owner. That means the park owner has taken over operation of the system from the serving utility. And they are now operating the system. They're responsible to repair and maintain it and so forth. In exchange for that, the park owner gets a discount on the energy. In other words, in my example, PG&E could bill electricity to the park on a wholesale basis, and the park can bill the resident on a retail basis, according to what the California Public Utilities Commission allows for the rates. The difference between the cheaper, the discount, if you will, that the park gets on the energy is called the differential discount. And that money is designed to be given to the park owner to repair the system, to maintain the system, or to replace the system if that's what needs to happen. Well, that means that if the park does incur repairs to the system, that money is already in their bank account. Even if they didn't earmark it separately, or even if they spent it, they already got it. And that means they can't pass that cost through to the residents. Otherwise, it would be double dipping. So years ago, back in the 1990s, GSMOL funded a major project before the California Public Utilities Commission to prevent what we call double dipping. If you live in a master metered energy park, the park owner can never pass through expenses relating to gas and electric repairs to the system, except for if there's a problem with the connection to your home, between the pedestal and your home, they could charge you for that because that may involve your home, which you own. or in connection with the common areas, clubhouse, grounds, swimming pool, something like that. Those kind of repairs could be passed through because they relate to the entire park and the common area. But otherwise, replacing transformers, digging up and replacing gas lines, all that stuff, they cannot pass that through. That's very important to remember. Same person had asked, please explain what leases are subject to exclusion from local rent stabilization ordinances. As I referred to a moment ago, under AB 2782, the long-term lease exemption contained in the mobile home residency law has been changed. And what the law now says is this Civil Code 798.17. What that says is that any rental agreement first signed after February 13th of 2020 is no longer exempt from rent stabilization. Any agreement, any lease or rental agreement which ends at that point is no longer subject to, or no longer exempt, I should say, from rent stabilization. Any existing agreement that predates, that was signed before February 13th of 2020 is still exempt, and you're not covered by rent stabilization until next January. As of January 1st of 2025, all leases, no matter how long the term is, are all going to be covered now by local rent stabilization. The exemption will end for all of them. Some park owners up in Sonoma County have filed a lawsuit about that in federal court, claiming that that's unconstitutional. We'll just have to see where that litigation goes. But as of now, that exemption is going to be ending. Last couple of questions before we can take questions from y'all. See, we have 58 on the line, so that's great. There is a question that comes from a lady who says that she and her mother were both on title to a home and were both on the lease. Her mother has now passed away. If I request that changes be made to the rental agreement to remove the name of my mother, does that give the park owner the ability to require a new rental agreement? The answer is no. You simply give the park owner the information. If you have more than one person on a lease and somebody passes away or somebody moves out of the home, you simply give them notice that that person's no longer here. But the agreement keeps going forward. Nothing should change in the agreement. And as well, it's not ever a requirement that an existing homeowner sign a new rental agreement. You have to sign a rental agreement when you first buy your home and move into the park. But when that agreement expires, and most of them would say in their terms that you automatically become a month-to-month tenant, you just go forward. There's only 7 reasons to terminate a tenancy, a mobile home tenancy in California, and expiration of a rental agreement is not one of them. So you can stay as long as you want, as long as you pay your rent and you don't annoy your neighbors and there's no code violations and you follow the park rules and regulations and the park stays in operation and you don't commit certain crimes on the premises. So a park owner can never require that an existing resident ever sign a new agreement, and removing a name shouldn't trigger that issue anyway. Part of the question also was, this person has a trust and they're going to put their home into a trust. That's fine, but you don't need to put the rental agreement into the trust, okay? The park owner is never going to agree to that because they don't make agreements with entities. They make agreements with real life people. Just because the trust owns the home, you don't need to put the rental agreement into the trust. So hopefully that clarifies that. Last 2 questions. This one I'm not really sure I can answer. When the homeowner moved into the park 18 years ago, there was an easement that provided an emergency exit for the back section of the park. It has 177 spaces. Apparently the easement no longer exists. Isn't there a law requiring more than one emergency exit for a park of this size? How could the easement, be removed? I'm not sure that we need an easement to have an emergency exit at the back of a park, first of all. An easement is um, sort of a part of land ownership rights, if you will, that just allows somebody to travel across land to get in and out of someplace without actually owning the land. For example, there could be a landlocked piece of property with a house on it, and the person needs to have the ability to drive across somebody else's land to get to and from their house. We call that an easement. It means they have the right to travel for ingress and egress, as we call it, but they don't own it. It may be that that's the case out back of this park where there's another owner of the land, and they took away the easement, and so now the park says nobody can get out the back because that's trespassing on somebody else's land. I frankly don't know, and I'd have to research it, whether there's a law that would say a park of this particular size has to have more than one exit point. It may in fact be the case. And if that's true, the park owner could have what's called a prescriptive easement in the back of the park, where the law requires that there has to be an easement. In other words, the thinking would be, if there's a law that says a 177 space park must have a back exit, and the landowner back there says, nah, I'm not going to let you come on my land, the park might be able to go to court and argue, I have a legal right to go across your land if there's an emergency. So that question really requires more detail and more information. The last question has to do with a park that has placed recreational vehicles, RVs, on mobile home spaces. Can they do that? Maybe yes, maybe no, is my answer to that. When you go on the Department of Housing website, there's a tab in the mobile manufactured home section of the website that says find a park. That's a great resource to use, for example, if you want to know, does my park have a current permit to operate? Or who is the owner of the park? How can I contact the owner of my park? If you go on the Find a Park tab and you put in the name of your park and then hit search, the park will come up and it will identify the number of spaces in the park and who the owner or management contact is for the park, the address and so forth. It's also going to tell you something else. It's going to tell you how many spaces in the park are permitted for mobile homes or manufactured homes, and how many spaces are permitted for recreational vehicles. RV spaces, if they're permitted for RVs, may not accommodate mobile homes. They're different. The size could be smaller. They have to have certain kind of drains in them because of the way RV, septic, if you will, systems or plumbing systems are set up. Mobile home spaces, however, in my experience, can accommodate RVs. So RV spaces may not fit for mobile homes, but mobile home spaces might accommodate RVs. And I'm not clear that it's in any way illegal for an RV to be on a mobile home space. It may be a problem. And I would say that if somebody has a concern about that, you should contact Department of Housing HCD and find out whether or not HCD would take a look at their records and say, that doesn't comply with the way this park is permitted. And so, we're going to come out and investigate it. And they may decide that they're going to tell the park owner, you can't do it. In this particular case, it seems that the park is just maybe even temporarily allowing RVs to be on mobile home spaces until something else happens. I understand residents in a mobile home park would say, we don't want this to turn into an RV park overnight. The only other law involved in this is in the mobile home residency law. It's provided that if a park is built after a certain date, the RVs must be located in one section of the park, in one designated area of the park. And that's in a new park developed after January 1st, 1982. So a park that opens up after January 1st of 82, if there's an RV in the park, it has to be in a designated section. They can't be sprinkled all through the park. If the park is older than that, then that law does not apply. And you could have a park where you have on one street, mobile home, RV, mobile home, RV, and so forth. I've also seen parks that have, it's a mobile home park and there's an RV park within the mobile home park. So it can get a little confusing that way. Well, I've talked for about 45 minutes and I've gone through all the questions and I presented the legislative issues, the 2024 ledge issues that I wanted to discuss. So Anne, if you want to take the reins back now and we can open it up for any questions for those listening online.
Thank you. Thank you very much, Bruce. Okay, so basically what we're going to do here is everybody's still going to stay on mute unless you are actually called upon. Each person will get one question to start with. We've got 57 folks here. We want to make sure that everyone has an opportunity to ask a question who wants to. We will circle back if we finish all the questions and somebody wants to ask a second question. And just like it was on Jeopardy, it must be in the form of a question, not a story. In other words, if your situation is very complex and you have a lot of stuff to ask, it would be a much better idea to consult with your local go-to person from GSMOL, whoever that might be, a region manager, zone VP, and if they don't know the answer to your question, they can arrange, the zone VP can arrange for you to actually consult privately with Bruce to answer your question. So if you have a lot of questions, that might be a better idea. Or if your question might involve a long exchange going back and forth. The main reason for this is just that we want to make sure that everybody has a chance to get their question in. We will alternate between taking hands that are raised and people that are putting their question into the chat. So Martha will be managing the chats. And she will take those questions that are in the chat and we'll go back and forth between me and Martha. And hopefully that will provide the opportunity for people that want to write into the chat rather than asking a question. So with all that being said, I see the first hand up is from Dave T. So go ahead, Dave. Take yourself off mute.
Okay, doke. Can you hear me?
Yes.
Okay, good. I've noticed with the water billing here in the park after, I think it was 1061 pass through, I think it's now 798.40. The section of tier levels, in other words, how much product we get for how much billing, has changed drastically. What we used to have, tier 1 was 0 to 4 CCF of water. I know one lady down the street that used 1 CCF and got billed tier 1, 2, and 3, which are seriously different prices. Mine are very much the same. I use somewhere between 3 and 6, depending on the time of year it is. And what I add up to an $8 bill can be a $12 or $15 bill on a monthly basis. I'm wondering, I called out, what the heck is it called? Weights and Measures, I think it was called. And they kind of threw their hands up and said, we can't do nothing. So I'm wondering, is there anything I can do?
Yeah, hi, Dave. Hope all
Hi,
is going
Bruce.
well with you. Well, I think, Dave, this is really an issue. This is going to really depend upon what, when you talk about the different tiers of usage, just so folks understand, typically, and it could be the case with other kinds of energy that's sub-metered as well, the more that you use, you might go into another tier, a higher tier of usage, which means once you go from tier 1 to tier 2, the volumetric charge could change, right? Because you're using more water in this case. This really has to do with the local water provider. It's not really part of the state statute. The state statute doesn't go into that. It doesn't drill into that kind of detail. 798.40, which you correctly identified, was aimed at eliminating these service charges, quote unquote, where park owners were just saying, yeah, we're going to charge you, $20 a month, or we saw charges as high as, I think, $50 a month to read your meters, or otherwise as a service charge, an administrative cost just to provide your water. And 798.40 eliminates that. But one of the ways that that law does allow you to be charged is for what's called the volumetric usage, meaning how much volume of water, in this case, you use. And that's basically keyed to what does the water provider or the water purveyor allow. So if your concern is the park owner might not be billing me correctly for these tiers, then you'd go to the water purveyor. If your concern is, I'm not sure if that's happening, but I just don't like the charges, the charges are ramping up, I'd still go to the water company, the water purveyor, and ask them, how do you bill these tiers? And if they say something to you like, well, you're not a customer of ours, so we can't tell you, I think that's when I've been involved in a couple of those issues where I've gotten involved and communicated directly with either weights and measures. That would be more of a meter issue, or with the water company directly to say, no, this is somebody who is an end user, right, of your water. I mean, you're obligated to tell them as a sort of end of the line ultimate customer how you're billing these tiers. But beyond that, I can't really, comment upon the fact that the tiers are going up. I just would have to have more information.
To the purveyor, their rates are posted in the office and online too, for that matter. The thing is, what the park is charging me for are not the same as those rates. And I have looked at, I believe it's called VSP billing, is the people who read the meters and do the billing in the park. And they claim they are doing it according to AB 1061, the optional calculation, which gives them permission to go according to the tiered rate the park is being billed for, but the park will not post their bills nor the formula they use to arrive at the tiers they bill.
Okay, well, this sounds like a pretty detailed issue, and if there is a violation happening, there could indeed be an MRL violation, because as you, I know, have read, Dave, because you sound, I know you're from past association, you're very knowledgeable and savvy, and you've obviously read the statute, but 798.40 C, let's see, it's C1, C1B says if the water purveyor charges for a volumetric usage based on a tiered rate schedule, and then it talks about how they can calculate it. I'd have to examine the facts to know whether or not there's a violation. If there is, then either it's an MRLPP issue, or maybe it's a direct attorney retention issue. If it's something that's more widespread, maybe it's something that GSMOL, legal budget could get involved with directly. But yeah, I would just need to know more information. It sounds like something worth investigating to me.
Can I send you some of my statements? And
yeah, why don't we have a discussion? You and I and Ann, we can have a discussion about that, okay?
Thank you.
offline. Sure.
Thank you. Okay, Martha?
Yes. The question is, Bruce, in Camarillo, we requested arbitration from the city. We were told the law prohibits information used in arbitration to be used later in court. We were asked to waive 2 laws in order to participate in the arbitration. Most of our complaints against our landlord are about him demanding that residents waive laws. How will this be dealt with in AB 2778?
How will,
The issue of them being asked to waive 2 laws in order to participate in
Oh.
arbitration.
no, yeah, I understand the question. In what we call alternative dispute resolution, ADR, which in many cases precedes a lawsuit. That could either be mediation or it could be arbitration. And also ADR is a standard part of any litigation, because many times local court rules will require that if a case does not exceed a certain dollar amount, it has to go to some kind of alternative dispute resolution first before it can go to trial. There's 2 kinds of ADR: mediation and arbitration. In mediation, the parties are usually in the presence of a third-party mediator, and you're attempting to settle the case or settle the dispute. And so the parties are, sometimes they meet together to begin with, then they break into separate rooms, and the mediator is going back and forth, seeing if you could settle the case. Well, it's a standard principle of California law that settlement discussions are never admissible against the party later on. And you can understand the reason for that. If you're trying to settle a case, let's say that I'm driving negligently and I hit Martha in a crosswalk and I injure her, and Martha sues me for $100,000, and we are now in mediation, and I say, I'll offer 20,000, and Martha says, no, I'll take 80,000, and I offer 30, and then she says 70. Well, all those discussions, let's say we don't settle the case, and then we go to trial, and if Martha says, well, Bruce must be liable because he offered to settle the case for $30,000. Well, that's not admissible. Otherwise, parties would never engage in settlement discussions, would they? They'd be too afraid. If I offer something, it looks like I'm guilty or it looks like I'm liable. So in a mediation, those discussions are never admissible later on. An arbitration is different. Typically, an arbitration is when you have a hearing officer. It could be a retired judge, could be a retired lawyer who's hearing a case and then making a decision. If that decision is not binding, and if somebody doesn't like it, they can then appeal it to the courts. But many times there's a record of it. There might be even a court reporter that takes that down, and so that could be admissible. If the parties, agree at the beginning, the arbitration will not be admissible in court. They can do that. They can both agree to that. It sounds like that's sort of maybe what happened here. But trust me, to get to the crux of the question, AB 2778 will not work that way. Not unless the parties agreed to confidentiality. And I would never advise residents to do that, because then you don't have a record to appeal. You'd want to go into AAA arbitration on a rent dispute, and you'd want the full record to be appealable to a court of law if the residents were unhappy with the result. So yeah, AB 2778 does not have any language that talks about confidentiality or waiving any rights that way. Yeah, we would never put that into the law.
Okay. I don't see other hands up right now, Martha, so why don't you go ahead with your next one?
Yeah, sorry, I couldn't find the date on this one, Bruce. The question is, what happened to the bill requiring parks to have management training? As I think that is to be implemented. Can you give us the date?
Yep, I have that handy because I knew that was going to be a question, and it's an ongoing question in people's minds because of the time that's passed by. So, in September of 2022, the governor signed Senate Bill 869 by Senator Connie Leyva, which addresses manager training in mobile home parks. That bill took effect January 1st of 2023. So it's been over a year now that the bill has been in effect. However, the terms of the bill required a ramp up. They required a period of time because Department of Housing HCD is putting together the training, the curriculum, putting together the whole administrative process, and needing to start collecting fees to fund the program. The bill had built-in language that says that the regulations for this will not be adopted until or on or before May 1st of 2025. So we're talking about the state. Obviously, the state has budgets and limitations on, staff and so forth. I know that HCD is working on this, but the actual program and the regulations are not going to be, shall we say, really in effect until May 1st, 2025 and thereafter. But the bill's passed. The ramp up period is moving forward.
Okay, I still don't see any hands up. Martha, do you want to go ahead? Do you have another?
I'm hopeful that in the background.
And we have a hand raised physically. iPhone 3, fourth row down.
Okay, go ahead.
Can you hear me?
Yes.
I wanted to ask specifically about a notification on our map that shows our emergency preparedness map that shows how we are to leave the park. It stated the owners of the park quoted Senate State Bill 23, and they have stated that per state Senate Bill 23, all residents are responsible for their own evacuation from the community. Management is not responsible under SB 23 to notify, contact, alert, or assist in the evacuation of residents in the event of an emergency. Is that what it really says?
I'm sorry, I'm not able to answer that because I don't know what SB 23 is or what it, when it was passed, what law it refers to. I do have the emergency preparedness plan law, if you will, in front of me. That comes from Health and Safety Code section 18603. And this is the same section that requires that in a park with 50 or more units, there must be a designated person, a manager, or any other person that's available in the case of emergencies. That law talks about the adoption of procedures and plans. Obviously, that's talking about exit routes and anything else that would sort of plan for an event of that. And it talks about, again, having somebody available in the event of emergencies. I don't know that there's any law that talks about the park having responsibility to escort people out of the park or to go knock on doors and so forth. But typically, as part of the procedures, there would be some kind of a warning system that would be built into the procedures. I can tell you that, but I can't answer any more specifically. I imagine that the park is always going to say that because even if they might have such a burden, they would try to distance themselves from it, right? To say that's not our burden. And if there's somebody who's not ambulatory, we don't have the obligation to call for an ambulance to get them out of the park. But I would say if you own property, and you've invited, tenants to occupy your property and something happens, and if you have the ability to save lives or property and you fail to do it, you could have liability under theories of negligence. And there may even be other specific liabilities in the law. So I think it's probably an overgeneralization in a way to just say, you're all responsible for that, we're not. But again, it's not like I think the park has the responsibility to, provide like a guide vehicle and escort people down streets and so forth. I think that's probably not required. But I don't know what SB 23 was. I can only look at, in terms of prior, I mean, I have to, look that up and see if it's available on Bill History Online. But I can only look at laws based upon the code sections where they're passed. In this case, it's the Health and Safety Code.
So would you recommend that I contact the owners of the park and ask what exactly this bill is they're referring to?
You could, or if you just want to ask the question of your zone vice president and they kick it up to me, and I could research it as well.
Okay, and the zone vice president for 10 is?
Region 10?
Yes.
Yeah, that would be me.
Okay, good. Then I will be contacting you. Would you kick it up, please?
Yes, I will.
Thank you so much.
All right, you're welcome. Okay, so she technically was a hand up, so we'll go to Martha next if you have another chat.
My question is, Bruce, on this program that was a result of the ruling by the PUC for the voluntary program that the parks can return the electrical system to PG&E. First of all, my park is doing it, and they're lying to the residents. They're saying it was required, which we know it is voluntary.
Correct.
The problem is that for the last 2 months, I have been trying to help some people. They're putting the meters in the driveways, which are unsafe. And I have been bounced for 2 months between HCD, PUC, and PG&E, and I'm having a nervous breakdown. What is the correct agency to whom to direct the safety concerns of these residents? Because everybody's saying it's not us, go to them.
Yeah, when you say meters in the driveway, I'm not sure I'm even understanding that. Are you saying that they're just temporarily putting meters in the driveway before the final installation?
No, they have marked the driveways as where they are going to install the meters. And there are 2 in my park that I and the residents consider very dangerous. So I'm trying to get resolution to have somebody come down and look and say, is this dangerous or not?
I'm not understanding how a resident can use their driveway if there's a meter in the middle of the driveway, but maybe I'm just not getting a mental picture of what you're saying.
It's on the side of the driveway, not very much room.
This is
but
smart meter?
don't know what kind of meters, whatever they're installing through that PUC ruling.
Well, I mean, I think it's a combination of either the serving utility or the safety division of CPUC. That's who should be involved. Yeah.
Okay.
I
All right.
mean, and if the park owner is the one saying, we don't want to, my understanding from all the hearings we had over the years is that when we have this line extension program where the old system's being abandoned and a whole new system's being constructed that all the ratepayers of California are paying for, which is not a mandatory, it's an optional voluntary program. And we're turning everything back to the serving utility. The park owner's getting out of the gas and electric business, which is not entirely a bad thing. That the new meters, the new smart meters, are typically going to be located in front of the home, in the little, landscaped area that's between the very front of the home and the sculpted edge of the street where the gutter is there, the curb. If it's coming in another area, that's kind of interesting. I don't know if I've, heard of that yet, but I think that it's an issue for the safety division of CPUC. If they say, we're not going to allow it in that area, or if they're saying we do, but it has to be with other, requirements, it seems like they would be involved. The plans have to be submitted to them. The park owner or the serving utilities plans have to be submitted to CPUC. So I would go to the safety division there. I think.
Thank you.
Thank you.
Sure.
Okay, next hand up is Maria Aguilar. Go ahead, Maria.
Hi, Bruce.
Hello, Maria.
I have a question. It's an on and off problem that we had with our park, with our amenities. We cannot use our clubhouse like an every day, only when we reserved it. But I have called also HCD and regarding other issues in the park, and the fact that they closed the complaints without even having like the lights fixed or even that issue establish anything. We spoke with the manager and they said they're gonna do it, but they don't do it and they close the complaint. And I keep calling HCD, but HCD says that that's all they can do. And what I mentioned is that I thought you guys were like the middle police between residents and owners, and obviously it's not, because we have a lot of issues that have not been resolved. And it seems like HCD, we cannot depend on them either.
Okay, well, without knowing what the specific items are, let me just answer what I think your question is this way. HCD, Department of Housing, has jurisdiction over the building codes and standards for mobile home parks. And those codes and standards are contained in the Health and Safety Code of California and in regulations adopted to enforce the Health and Safety Code, and we call that Title 25. And Title 25, for example, here's my copy of that, has an entire section that is specific to mobile home parks, if you will. And Title 25 contains installation regulations, if you will, and operational regulations for mobile home parks. It talks about permit process, electrical requirements, fuel, gas, and oil requirements, plumbing, fire protection, lot lines, setbacks, earthquake bracing, fences, storage cabinets, which we call sheds. All of that's in Title 25. Those are laws. Those are codes and standards, like building codes. Lighting is part of that. Title 25, you mentioned lighting, has specific requirements for the candle power that's required for street lighting in mobile home parks. If you have any complaints about any of those areas, then you can go onto the HCD website and you can file a complaint, a health and safety complaint about conditions in the park. HCD will investigate those. Or if there's just not enough there, they might say, look, you haven't given us any information that looks like there's any violation. We're not going to do it. But if HCD believes there even could be a health and safety issue, and that could be anything from a gas leak to a trip and fall hazard in a sidewalk, in front of the clubhouse, then presumably they would investigate that. And a complaint would be opened that they would then come investigate. If they close the complaint, it means presumably they've investigated it and they don't find a violation, or the violation's been corrected. So that's one kind of area where HCD is directly involved. If we're talking about a mobile home residency law complaint, rental agreements, clubhouse isn't opened, I can't sell my home because they're interfering with the resale, they're charging me illegal charges on my rent bill. Those are not building codes and standards issues. Those are mobile home residency law issues. That's the civil code, not the health and safety code, a whole different law. Those are the issues we've been talking about today that the mobile home residency law protection program deals with. HCD is only the administrator of that. They don't come out and investigate. They don't tell the park owner, you need to open the clubhouse. That's a civil issue, okay? that's where you file an MRLPP complaint and get a local legal provider to help you, or you contact your regional manager or your zone vice president and say, hey, we got this issue, and can GSMOL, get involved to see if we can resolve it. The clubhouse availability is a perfect example of that. In the mobile home residency law, as you may know, 798, a series of civil code has this very specific section that talks about the posting and availability of common area facilities, the posting of hours. Common area facilities must be open or available to residents at all reasonable hours. If they're saying you have to reserve it, I don't believe that complies. If they're saying we've had crime in the area and to get into the clubhouse, you have to call us and we have to open it up, maybe, if there's good reason for that. I've seen that happen in a few parks. But simply just locking up the clubhouse and saying, until you submit a reservation and we, get around to looking at it and deciding whether you can use it, that, in my opinion, is a violation of the mobile home residency law. That would be the kind of thing that the MRLPP would govern. Do you see that distinction there?
Yes, I do.
Yeah, so they're pursued differently and separately with HCD, but again, codes and standards issues, trees touching mobile homes, sidewalks buckling up because of tree roots or disintegrating, any kind of hazards in the park, that's health and safety. That's a different complaint process.
The lights, it's a like you said, it's health and safety, and that's what I mentioned to ACD. But
Well,
they
did you actually file a complaint about that?
yes.
Yeah, well, I don't know what to tell you. I'd have to know more about why they say they're closing it. Did they investigate? Did they actually come out and look and test the lights? I don't know.
That's what I told the lady. She says, well, yes, I went and I saw that they're not properly working all, but they said they were gonna fix them. So I told her, why are you closing the complaint without even?
Yeah, that doesn't make any sense. If there's a health and safety Title 25 violation, there should be a citation issued to the park owner, and they typically wouldn't close the complaint until that's resolved, until there's compliance. They typically would inspect, find a violation, cite the park owner, and then come back for a reinspection to determine if the park owner has complied. And if the park doesn't comply, it could go further and further. The nuclear option would be to suspend the permit to operate until the park complies. But I'd have to know more. I'd have to see the documents here and understand the problem before I could, comment further on that.
Okay, thank you.
Sure.
Yeah, Maria, you might want to ask either Martha Vasquez or Mary Jo to intercede with you and maybe get a consultation with Bruce.
Okay, thank
By
you.
the way, my next door neighbors had people chainsawing all morning, so hopefully that hasn't been a bother to anyone. But if you hear buzzing in the background, there's large trees coming down next to my house.
Uh-oh. If we hear a crash and we see a big branch in front of you, then we'll know what happened.
You'll know what happened.
Yeah. Thank you. Martha, do you have another chat?
Yeah, one just came in. Is water leaking a safety issue that the park has to repair and keep from flooding my space?
Well, when you say water leaking, I'd have to know where's the water leaking from. If water is coming down a hillside because of improper drainage, there's no drainage being provided by the park owner, or there's no retaining wall perhaps that would be required to divert water away from your space, and water's collecting under your home, that's the park's responsibility. The park is responsible for the soils and the elevation, issues that may cause water to be ponding, pooling, or flooding. If leaking is coming from your home, that's your responsibility. If the water is coming from somebody else's space, then you should be demanding from the park, you need to tell that person to fix their leak or otherwise divert the water from their space onto my space. And that would be the park's obligation to do that.
Mary, if you could unmute, and Bruce needs a little bit more information on your question. Where is the water leaking from?
Well, it's leaking in the row above me, and it's been doing this for a couple years, and the park hasn't really done anything about it, and it's just gotten really bad because now we're in the middle of the utility conversion program, and so the stuff along with really the rain isn't the problem, it's the way it's being diverted because of the road damage and digging up and stuff. So anyway, my space is flooded in two areas, and nothing is being done about it. And I'm just kind of, frustrated because I'm not the only one. There's more people. At least I want to estimate 18 homes that have had to put up with this on their street for at least 2 years. And they just seem to think they can just keep doing this and with no consequences, just letting it go on with this water constantly flowing and nothing being done about it. But now it's specifically going into my area because of the diversion, because of the road dig up trenches and stuff.
So it sounds like this is not what I would call a leak. I would call a leak where a pipe is leaking water, unless maybe that's the case. But if it's an underground line, water line, that's the park's responsibility for the leak. If it's just that there's a higher elevation behind you and water's flowing down the hill sort of naturally, especially at this time of the year, and there's no proper diversion or way that it's being taken off, that's totally the park's responsibility.
Well, this is year round. It doesn't matter what time of the year. And like I said, the people in the row above me, they're putting up with it over this long period of time.
I'm just wondering where the water is coming from. If it's in the middle of the summer, where's the water coming from?
Well, they're finally supposed to get this detection service out here, but that does not mean if they find where the actual leak is, that they'll actually repair it, because they don't do anything for our infrastructure whatsoever. So it's really pretty concerning. My yard's getting drowned, and quite honestly, I had the most beautiful garden and yard in the park because I'm that's what I do, and now it's pretty much ruined. So it's I
Well,
feel
it's-
in a way it's almost that they've let it go this far, retaliation against me, because I'm the one that writes the letters and filed the complaint with HCD about our clubhouse and all these things over the last few years. So I don't really have a open line of communication unless I put it in writing, which does help. But everything you're covering today is phenomenal. Thank you so much for this information. Thank you, everybody.
Well, if I was you, I would organize all the folks that are having this problem, and I would file a complaint with HCD. I think it's a health and safety issue, not an MRLPP issue. It's a
Okay.
health and safety issue. And consider, finding somebody local who could even represent you. If your property is being damaged by this, then those are damages. Those are money damages, and it's flatly unsafe. It could be viewed as a breach of contract when you rent. As a renter, you're a homeowner, but you're renting, so you have a tenancy, and you're entitled to what's called quiet enjoyment. And living under flooded conditions is not quiet enjoyment. That's a breach of contract. So yeah, I mean, those things kind of pop up for me right away. I'd be taking video and
I am doing that.
evidence, and I would be, keeping track of any loss that I have of, vegetation or anything. How much did that cost me to plant those roses, and now they're gone, whatever it might be. I'd start doing that. 18 people come together, you could make a demand on the park owner, and maybe it's time to have an attorney do that for you.
Okay, thank you, Bruce.
Sure.
Thanks. Okay, so the next hand we have comes from somebody that I haven't seen for quite a while, Tim Sheehan.
Yeah, look at
Welcome,
that.
Tim.
Hello. I've got a question, but first I wanted to mention SB 23. I think that was the old Alex Padilla bill from 2008 or 2007. that required the parks to create an emergency preparedness program and then post it in the clubhouses. So I hadn't heard about that much lately, but my question was about AB 2782 and whether GSMOL will be printing an advisory that could be used by members to take to their cities and inform residents of our communities about this, and whether GSMOL will be contacting cities directly to give them the heads up and using the League of Cities or any way to get the word out to both these governmental entities and members and homeowners at large also, because it's going to make a big difference in a lot of areas. Thank you. And good to see a lot of familiar faces.
Yeah, thanks,
Thank you,
Tim.
Tim.
Yeah, great thought. I think there's only been some very preliminary discussion about that. I know that the question I get is from a resident or a homeowner who says, what do I have to do? Like, do I have to do anything? And I say, well, it's not that the law obligates you to do anything, but clearly you want to communicate with management. If you're on a long-term lease presently, that's going to lose its ordinance exemption January 1st of next year, you'd want to make sure that your park owner, your manager understands that's the law and will start billing you correctly. So other than just making that communication, homeowners have no burden or obligation. It's not like this only happens if you do something. But what you say, Tim, is a great idea. I think that probably the board should be looking at creating that kind of communication that will, on a much broader scale, provide and disseminate the information about how things are going to change once January 1st of next year rolls around. And the lawsuit that has been filed by 2 park owners up in Sonoma County, they have not pursued an injunction yet as part of that lawsuit. So the bill, stays in effect, the law stays in effect until a court says otherwise.
Thank you. Martha?
No chat, over to Henry.
Okay, Henry, go for it.
Hi, this is just a protocol question. There was someone with a telephone number from the 805 area code ending in 55 that had their phone unmuted for a while, and I was thinking that person might want to speak. So I wanted to remind, if you're calling in by a landline or a cell phone, *6 will mute and unmute yourself, and *9 will raise your hand so you can be called on. So for whoever had the phone number from area code 805 ending in 55, if you would like to ask Bruce a question, *6 to unmute, go for it. Otherwise, back to Ann.
Okay. I see no other hands up. So this is your chance to ask Bruce a question. If you have a question, you can either put it in the chat and Martha will get it, or I will take your hand. Okay, Tim, back to you.
Well, one issue we're dealing with our national group is the solar issue, and I was wondering, and replacement of pre-HUD homes, pre-1976 homes, and I was wondering if any of the utility companies in the state, if anyone's aware of working with local jurisdictions that might have a rehab program or incentives to either repair or replace pre-HUD homes, have tried to reach out to utility companies to incentivize replacing the pre-HUD homes, and if they did that, the utility companies could put solar panels on those new homes, and whether split the profits or provide low cost energy for the homeowners of those replacement homes, but enable the energy or the utility company to share in that revenue. A lot of the utility companies have had programs for energy efficiency and retrofitting homes, so that the homeowners didn't have to pay out of pocket. And I was just curious to know if there's any if anyone is aware of anything in California where there's been a partnership between either local government and the utility companies to create these incentives for replacing the pre-HUD homes or other things along those lines to help generate more solar panels and energy generation in the manufactured home communities.
I'm not aware of anything like that. Sounds very interesting. And I think if we might want to actually maybe communicate with the national Tim on the solar issue if you're all at that level kind of pursuing that as well. But yeah, I'm not aware of anything like what you just described. I don't know if anybody else is.
Okay, just checking. Thanks.
Yeah.
Thank you, Tim. Okay, so we have a phone caller, 805 area code, number ending in 8490. Go ahead. Okay, phone caller, phone number ending in 8490. Go ahead.
Hand is raised.
Your hand is up, but, and you don't appear to be on mute.
Am I okay now?
Yes, go ahead.
Okay. All right. I'm out at Sandpiper in Cambria, and we're a master meter community. And what my intention is to upgrade my kitchen from gas to all electric. And that's going to require a lot of electrical work in the service panel and things of that nature. And also to upgrade to receive solar when it becomes available. Would I be responsible for all these costs, or would the park would be reliable for some?
If you're upgrading your own home, that's all your cost. The park is not responsible for any of the cost to upgrade the interior of your home. Now, if your home has doesn't have the capacity, to connect to the new system, there may be parts of that, the connector between the meter or pedestal and the home. There could be some portion of that could be the park's responsibility. But if it's any part of your home structure, the connection plug, if you will, on your home, anything on the interior of the home, that's all your responsibility. Yeah.
Okay. All right. Thank you.
Uh-huh.
Okay, Martha, any more chats?
Yeah, Dave T, I don't understand your question or comment, so could you unmute and tell us what SCE does have an MH partner mean? Dave T, there you go.
SCE is Southern California Edison. That's
Yeah, with respect to the last question about the guy that was looking for a way to get solar panels, I can tell you that SCE on their webpage or website, they have mobile home partners, they call them, that they classify as professionals in the mobile home industry that will come out and look and see if what has to be done in order to upgrade to solar panels, like primarily on places that are pre-HUD. I like that terminology. The roofs just aren't strong enough to hold the panels. So it is a major cost to upgrade your trusses to something that will hold a solar panel. And I've looked into it before. That's how I know SCE does it. I was doing a search right now, but I don't know where the gentleman was located to see if SCE is his electric provider.
It would be because he's in Carpinteria.
Okay. Let me finish my search and I'll post it in the chat box, see if that's any help.
Thank you.
Thank you.
Anyone else? Either with a raised hand or in the chat? Nope.
Been a good meeting, as
It's been a
always.
great meeting.
If
I
you liked
want-
it, folks, yeah, go on our website, check out the Ed Fund, and, you know, anybody who's not a member of GSMOL, please join. These are the kind of informational meetings that provide great value to all of us, myself included, and to Ann and Martha and Henry, you know, your volunteer leaders. And, you know, being united together, being knowledgeable and vigilant are the keys, you know, to protecting your lifestyle.
Thank you. I would also like to say that the video of this meeting will be posted on the GSMOL website. It will take a little while to get it into post-production, but we do have a whole collection of videos of these town halls. And if you look at the bottom of the website, down at the bottom, you'll see town hall videos or some such thing down there that you can click on. Please promote GSMOL in your park. And another thing I think is important is to know who your GSMOL go-to person is, because we have regional managers, we have associate managers, we have zone VPs. All these people are ready to talk to you. If you get the Californian, which is our magazine, which is now an e-magazine, if GSMOL office has your email address, you will receive that as an e-magazine. And in there, you'll find a who's who page where you can look up who your go-to person is, or you can look them up on the website on the contact page. So, and I'll just echo Bruce's comment about know your rights. I mean, you know, if you know your rights, you're less likely to be taken advantage of. And that's, of course, why we have these town halls. So, and yes, and Martha reminds me that you can get a printed copy. And all you need to do is contact of the Californian, that is, and all you need to do is contact the office, and they will send you a printed copy, if you remember. So thank you all for being here. Thanks to Bruce. And I hope you all have a wonderful rest of your day, and bye for now.
Yep. Thank you, everybody. Take care.